This is a brief video responding to some frequently asked questions about the impact of COVID-19 on estate planning law. The information in this video does not constitute legal advice or the formation of an attorney-client relationship. This is strictly for informational purposes only. Today is June 15, 2020, and these are your updates as of today.
What happens to the stimulus check of my loved one if they pass away prior to the check being received? If I'm married, if the check was my parents, or the check was for my child.
The stimulus payment was issued based on an individual's 2018-2019 income tax returns. This has resulted in payment to individuals who passed away after the returns were filed. It was thought that the government planned to allow heirs and spouses to keep the check. There have been no specific guidelines issued, and the CARES Act, Coronavirus Aid, Relief and Economic Stimulus Act, does not have a clawback provision, which would give the IRS power to take back the money. Therefore, for now, it is unknown how this will be handled. We are awaiting guidance from the government. The Treasury Secretary of State, Steven Mnuchin, wants the relatives and estate to return the money. The CARES Act specifically excludes estates and trusts from the stimulus payments.
Both of my parents passed away. They own a home and a car. They do not have a will. What do I do?
We have to first determine who died first. Let's say it was Dad. If all accounts in the home were held jointly as husband and wife, then the accounts and the home was inherited by the wife. Then when she died without a last will and testament, her heirs inherited. If she had children, they all inherit equally. If any of her children predeceased her, then it's the grandchildren of the predeceased child that inherit that child's share. An administration proceeding should be commenced in the surrogate's court of the county where your parents resided. That individual would gather the assets, pay all the outstanding bills, and distribute the remaining assets to the heirs. The real estate, the home, vests in the heirs at the time of death. It is, in its simplest definition, if mom had 3 children, all 3 now own 1/3 of the home. The Department of Motor Vehicles has a form you can use to transfer the car. You can go on the website and have the title transferred to an individual. The heirs may all have to sign the transfer documents. The proceeds received from the sale are split amongst the heirs' children and or grandchildren.
My dad passed away due to COVID-19. My mom needs access to the money from his account to pay for the burial, but she is not a signer on his bank account. What can she do?
Unfortunately, the bank will not release the money to her unless she is the beneficiary of the account or it is in a trust for her. She will have to commence an estate proceeding in the surrogate's court of the county where he resided.
What is a healthcare proxy and do I need one?
This form allows the person you choose to make all healthcare decisions for you, including the decision to remove or provide life-sustaining treatments. Healthcare means any treatment, service, or procedure to diagnose or treat your physical or mental condition. The person you appoint must be 18 years or older and can be a family member or a friend. This individual will make medical decisions for you when you are unable to make these decisions. If you have not executed a healthcare proxy, then New York's Family Healthcare Decisions Act will come into effect, and it will allow a family member of the patient or a close friend to make healthcare decisions for a patient who is in a hospital or nursing home. This is important. This only comes into effect if the patient is in the hospital or nursing home. Under the Act, the individual has to be determined to lack capacity to make healthcare decisions. Under procedures specified in the statute, then a surrogate is chosen to make all healthcare decisions in the following order of priority. Legal guardian appointed under Article 81 of the Mental Hygiene Law, spouse or domestic partner as defined in the Act, adult child, parent, brother or sister, close friend, age 18 or over, or a relative other than those listed above as defined in the Act. If no one in the above is available to do so, then the Act has a specific procedure to follow. Everyone should have a healthcare proxy, so you have control over who will make all medical decisions for you if you are unable to.
What is the power of attorney and should I have one?
A healthcare proxy deals with your medical needs. A power of attorney deals with your financial needs. You appoint an agent who will have the power to handle your finances. You will be able to specifically state what powers you wish to grant the agent. the power over bank accounts, stocks, bonds, and or real estate. With the power of attorney is a statutory gifts rider that grants your agent the power to make gifts of your property, which are to be in your best interest.
What is a MOLST?
It is a medical order for life-sustaining treatment. This form will document an individual's preference concerning life-sustaining treatment. MOLST is for patients with serious health conditions who 1. Want to avoid or receive any and or all life-sustaining treatments, reside in a long-term facility, or require long-term care services, or might die within the next year.
Do I need a last will and testament?
When you ask an attorney, the answer is always yes. In a last will and testament, you designate the person or persons you want to inherit your assets, bank accounts, real property, etc. You also designate the person you want to be in charge. That's the executor. If you do not have a last will and testament, then your assets will be divided in accordance with the estate powers and trust law. What if you have a child who is disabled? You may want to leave them their inheritance in a trust so that they don't lose Medicaid or supplemental security income. You can accomplish this in your last will and testament.
Do I qualify for the economic impact payment of $1,200 if I receive veterans benefits, supplemental security income, or Social Security, retirement, disability, or survivor's benefits?
Yes. If you did not file an income tax return for the years 2018 and 2019, you will still receive the sum of $1,200. If you have a child under 17 years old, you may have to provide the IRS with information in order to receive the extra sum of $500. You still have to meet the financial requirements of the Act. For example, an individual must have an income below $75,000 a year.